All right, good morning, everybody.
Good morning.
If you can hear me, you're sitting too close. Right? Thank you very much. So, anybody go to the game this weekend, to the Raiders game?
My husband did.
So, my first time in the stadium, it was very cool. I got to say, I've not been to a major football sporting event since I was like 10 years old, because I grew up in Las Vegas. We didn't have teams when I grew up here.
10 years ago?
Yeah. Yeah. Funny guy. So I got to say that was really cool, and I definitely would go again. Anyone going to the Knights tonight? The Knights tonight? Yeah, we got a few people. Fantastic. All right, well, we're going to get started. Who's watching the market numbers with the real estate market and the listings that are out there? Yeah, just the lender, huh? I'm glad the rest of you showed up today to sell something. So what do you think about the market? Is it better, worse than it was last month? The same?
In what sense? Better?
I don't know. You tell me. You're the salesperson.
Longer days on market?
Okay, longer days on market. So I want to talk about that for just a second, because we're starting to have sellers freak out because their home doesn't sell in 2 days. Anyone have that yet? Okay, just had a seller call me up and say, wow, my property's been on for a week. Do you think we should fire sell it? Right? Seller actually decided they want to do a $20,000 price reduction. And do you ever tell a seller no? I don't know. I told the seller, I don't know that we need to fire sell it, but I think that if you want to adjust the price to be more competitive, I'm completely on board with that. Sound like the right way to sell that, huh? But the whole point is that people are getting worried because things are changing a little bit. What really happens during the market in this time right now? Everyone's been here before. What happens in October, November, December? It slows down. Why? It's the holidays, right? And so the argument right now for most sellers is that during the holidays, I should just wait to list my house and I'll sell it next year. And I would argue that the holidays are the best time to sell your house because it looks the best. You prepared it, your family's coming in, so you want it clean for that 1 hour before they get there, right? But why else? The most serious buyers in the marketplace that are going to get in their car and drive around when it's 55 degrees outside like this morning, they're committed, right? I know that's cold for you guys from the back east. But the whole point is that we need to be able to interpret what's going on right now for our clients so we don't freak them out. Would you agree?
Yes.
What else is going to happen, do you think, in the next 3 months?
Interest rates will go up.
Okay, so they've been talking about the fact that interest rates could go up. I don't know, if they went up 1%, would that really cause you to stop buying houses? No? I mean, would we be at 4 yet?
Yeah, 4 would be.
Okay, oh, man. I think my first house was like at 6.9, right? But what else could happen? The world could end, yeah. What do they always say? I'm going to wait till next year, right? We're close enough to the end of the year that people are going to start using that line. And what is the reason they say till next year? It's the tax purposes, right? So give me a good reason to buy a house in this year for taxes.
They're raising taxes next year.
They're raising taxes next year. That is a complete possibility. Do you know that we're going to go to a meeting in about a month to talk about the fact that the capital gains tax issues and the 1031 exchange could completely go away? So if you're an investor and you're going to 1031 your property and save on those taxes and move it to another entity and that could go away, do you think next year is a good time to sell? No, not at all. So just the whole point about all this is right now on Las Vegas Realtor, on your MLS login, the countdown clock has been removed. And you'll be able to see now that they have the market stats out there. That's a joke for all of you that were following. And if you're not reading these market stats, right now is when clients are going to start to get scared, and when your listings are going to start to wonder why it's going to take 30 days to actually sell. I want to make sure that you're spending the time to figure that out and you have a good reason to tell them. So we're going to bring up Myra with Prosperity to share a little bit about the mortgage market. Give Myra a hand.
Hi, happy Tuesday. I have some exciting news to share today. I don't know if you guys have heard or not, but conforming loan limits just got an increase. So they went from 548 to 50. The new limit is now 625, so it's like 76,000 more, which is amazing. And then keep in mind that this is total loan amount. So this equates to like a purchase price of like 655, 657, give or take, minus like a 5% down payment, leaves the total loan amount to 625. And that's on conventional financing. FHA hasn't been announced yet, so stay tuned for that. And not all lenders are already starting this conventional loan limit. We are. So if you guys have anybody, just let us know and we'll be happy to help.
Very cool. Thank you, Myra. Okay, so let's go over a few announcements real quick. Sherry, you want to tell us about your great raffle? And yes, I bought tickets today because she has Makers 46 for all of you at home. Too bad you're not here to buy tickets.
And Valentine.
Give it up for Sherry KK.
And Valentine's Scotch and tequila. So even if you don't drink, kids, your clients do probably. Or they will after we buy or sell a house, right? Okay, so good morning, everybody. Let me just first say, the Tata Alliance event last Saturday was a total success, but wait till next year. So remember, you guys, in October, we are all over the breast cancer cure, looking for a cure. And we work directly with the American Cancer Society. There's no middleman, it's no weirdness. But we had a great lunch in downtown Summerlin. California Pizza Kitchen donated the room, gave us discounts, it was fabulous. And Brighton donated a fabulous bracelet, the breast cancer bracelet. And I do have coupons in the back. If you do want to buy that bracelet, they will donate $10 to the American Cancer Society for every bracelet that is purchased. And I have little coupons for that. Anyway, all the local downtown Summerlin that we got, the donations were fabulous prizes we raffled off. It was a great, great thing. So next year, it's even going to be better because this was a first. So anyway, on that note, I am raffling off this booze. I calculated how much we made last night, and Roya swears it got to be more because I wrote it down on a piece of paper and it got wet. So my husband has it at home. Anyway, I will have that number for you, but it's been really great. This is our last Tuesday that we're donating, or raffling, I mean, and because next Tuesday now, pay attention. Next Tuesday is the meeting, office meeting is here, and the bake sale is here. Ladies, gentlemen, if you bake as well, bring your baked goods early so we can sell them. We'll be setting it up in the lobby out there. It's a great event, and again, all the proceeds go to American Cancer Society Breast Cancer. And what else do I want to say? Oh, okay, so on another whole different note, Signature Strong every year buys a booth at the Military Appreciation event. This event's been going on for 7 years, minus 2020. This is the 7th year. And I've been involved with it minus the first. And I used to man our booth. Now I man the volunteers for the event. Don't ask me how that happened. But anyway, it's a really, really wonderful event. If you are military, if you are any armed forces, first responder, it's free. It is free for civilians. There's a classic car show, but for civilians, there's food trucks to eat. The food is also free for the veterans. It's a total wonderful way to give back to our guys. They've worked very hard for us in all different, branches of the Army. The military. If you do come, I strongly urge to be there on the opening, which is at 11 a.m. It's a fabulous, fabulous show. Every branch of the military does a little act. Okay, so on that note, is there
When
anything
is it?
else? That is, I'm sorry, October 16th.
4 days.
Where's my,
It's online.
You just did it. It's online now.
October 16th, flyers are all around. Oh, and that's for those guys, right?
Yeah.
For that home. Okay. Is there anything else I need to say?
No.
Okay. I'm still back there. I will do the raffle at the end of the meeting.
Give it up for Sherry. And last but certainly not least, we have Janet, who's got some announcements for us.
Thank you. I really only have one real announcement. Friday, October 22nd will be the last general membership meeting and luncheon and CE class for the year. So if you want to go, Jeremy Aguero, Chris was talking about stats. He's the one that does the stats for LVR. He's going to give his economic forecast during lunch. And then after lunch, there will be a free CE class. Yes, Todd? Okay. After lunch will be a free CE class. It will be law. The instructor's J.C. Melvin, so it should be entertaining, and it's all free. But you must RSVP, put $35 on a credit card or your account, and if you show up and sign in, lunch at the Four Seasons is free, the speaker is free, and the CE class is free. If you don't show up,
It's not free.
yeah, you'll be billed for $35. So please sign up. We'll reserve a couple of tables for signature agents, but do it now because I think registration ends Friday. I'm not sure.
Sounds good.
Okay, Todd, you had a question.
Longest CE class for ethics on the 27th, and there's about 30 people in the company who don't have their ethics for this year, and they're going to lose their membership at LDR on December 31st if they don't get in. First class is free. You need to come to that class.
27. What time? 1 to 4?
I think it's 11.
I think it's 11.
I remember this was
Okay, so Vandana is teaching an ethics course on the 27th of October. They're what time?
1 to 4.
1 to 4. There are approximately 30 people in the company who have not fulfilled your triennial ethics requirement. And if you don't do it by December 31st, guess what?
You're out.
kick you out.
You are no longer a realtor. So if you have not taken this course, just because you took ethics does not mean it meets the triennial ethic requirement. So how do you find out? Log into Las Vegas Realtors to your home page, and somewhere in the middle of the page it will say ethics complete, or it will say ethics incomplete. If it says incomplete, you need to be in that class because come January 1st, you're no longer a realtor.
Hey, Todd got a class. Todd's got a class, I got a class on Thursday.
Read your newsletter.
Read your newsletter. All the information is in there. Todd has a class this week, and so does Tom. Todd's is on business planning. Tom's is on
Prelims, baby.
prelims. You need to be able to read those and explain them to your clients. And so it's all in the newsletter every date that we have on the calendar through the end of the month. Thank you.
Thank you, Janet.
How to keep your butt out of the seat with
Yes.
standards.
So please make sure you get those ethics requirements done, because if you don't, you have to go back, and to get reinstated, you have to sit through orientation again, which, you know, is a fun time.
2
It's
days.
three days, because you have to do the MLS portion
Oh,
again.
shoot.
Okay, so I'm going to welcome up to the stage my favorite attorney. If you ever would have told me I would have had a favorite attorney, I never would have believed it. But I want to welcome up Dave Sanders. Dave, come on up and take a seat.
Hey,
But while Dave is getting up here, I do want to do some listing or buyer wants and needs. So who has a listing they want to tell us about? Roya, you had your hand up first. Here, just speak into the mic.
Okay, hi. We have a single story in Southern Highlands, about 1,800 square feet. There's a casita, and it's one of 5 that are on the market right now, so it's in, like $488 is the price. We have a duplex, which is an investment property that's on the east side, so like Boulder Highway and Russell. That one is listed at $389. And we have one in the southwest it's called Divine Ridge, a 7375, Divine Ridge. It's a 2-story with a pool, $460, and it's got 4 bedrooms. And you can do an open house for that one.
Very cool. All right. Come on up. Looks like no camera right here, but it's okay.
We have a listing going live this coming Saturday up in Providence. It's in a gated community. It's a 1-story, 3-bedroom, 3 full baths, 2,544 square feet. The lot is a little over 9,000, and it's a 3-car garage at 600,000.
Very cool. Who did I miss?
anybody?
Was that?
You know she's related to Veronica Torres?
I know. I found that out.
Holy mackerel.
Do not.
Focus.
I'm focusing. Listing going live in Summerlin South. It is 1,288 square feet, 3 bedrooms, 2 baths, 2-car garage, and it will be listed at just under $370.
In Summerlin?
Yeah.
Wow.
370.
That's under the market
370 in
median.
Summerlin?
370 in Summerlin. It's already sold. Okay, anyone else have one that I missed? No, fantastic. Okay, Dave, how you doing?
I'm well.
Let me get you a microphone here. There you go.
I am well. How are you, sir?
Very good, very good. So before we get into everything, and I've got my list of questions that have been submitted by me. And so as I go through this, if you guys have any questions at all, please just raise your hand. We want to get to those first. Dave's here to share with us a wealth of knowledge. But before you do any of that, tell us what the court system looks like right now because of COVID and how you guys are dealing with that.
It's a mess, to put it kind of succinctly. So we have started doing some trials, but pursuant to the Nevada Constitution and the U.S. constitutional criminal actions have to go first. So you're looking at, if you ask me today to file a lawsuit, our best case scenario for trial is going to be 2022, maybe even 2023, if not beyond that. Just to kind of give you an idea of how bad the staffing issues are down at the courthouse, I'm probably the only one in the room who's ever got a speeding ticket. And so if you ever had to go down to the courthouse, there used to be a gigantic room called Traffic Services, where there were about 25 different windows with court assistants and staff to help you with your ticket. They have completely shut that down and turned every one of those windows into evictions only. Seriously, they did that in August, and they have no idea when it's going to stop. So, so we have the eviction moratorium that is coming back. You've had, essentially no trials for over a year and a half, which even before COVID, it was a 2 to 3 year wait. So you have that issue. Just with the court system in itself, there's a massive backup. I mean, small claims is still active and it's still as crazy as it always is. Small claims is active, but anything beyond that, justice or district court, we're talking pretty substantial delays. So if you're having earnest money disputes, if you're having those kinds of issues, I certainly recommend that you have your client speak to an attorney who can give them the idea of just how long it may take for them, particularly if they're fighting over a smaller number. If it's less than $10,000, you will be going to small claims. You might be able to get a hearing before the end of the year, but it's certainly in everyone's best interest to kind of work out a resolution in advance.
So that's actually next on my list is we've had a lot of issues come up lately because there's a number of cancellations going on in the marketplace. And it's pretty prevalent right now, which is kind of crazy with the shortage of inventory, and so we're seeing a lot of earnest money disputes. Explain, just so we understand the process on small claims court. What would we have to go through as a consumer? What would we go through if we had you as our attorney and did the same thing?
So earnest money disputes are, frankly, a bit of a difficult scenario. If you're talking about an earnest money deposit of less than $10,000, it becomes extremely expensive to retain counsel. So the first thing is if you did indicate the mediation provision in the RPA, then you're looking at mediation costs. There is a free service. Unfortunately, LVR doesn't offer mediation anymore. They've decided to go down to the neighborhood justice center. The neighborhood justice center is nice in the sense that it is free. It is not nice in the sense that they do not accept any documents. Really, they do not want any documents from you. So if you're going to try to prove that this was a COVID-based related, or if there was a failure, they're not going to see the documents. That's not what they do. Their process is really just to be more of a facilitator. They're going to sit down, it's free, and they'll say, Chris, tell me your side of the case.
I'm right.
They'll say his case. And then they'll say, Dave, tell you your side. I have a client that's retained me to do a mediation over a real estate transaction where they're alleged to be failure to disclose property conditions. Well, we're going to mediation next week, and guess what? I do not have any idea what the buyer actually wants. They have not sent us a demand. They have not provided any documents. And now it's back to being in person, so my clients are like, what's going to happen? I'm like, I don't really know. We're going to go down there and show up. Hopefully they've got some documents, but at this point, I can't tell you what they want. I tell you we have to go because we signed up for it in the documents, but beyond that, this may be a gigantic waste of our time. So that's mediation. Now, if you're talking about a higher price point, $20,000, $30,000, $40,000, $50,000, there are a lot of mediation services out there. Former federal judges, former Nevada Supreme Court judges, there's a lot of that. The downside, their hourly rate's going to be $300, $400, $500, $600 an hour. So you either go down to the bare bones that the county offers, where they don't want to look at the RPA, where they don't want to see your paperwork saying, oh, I couldn't get a loan because of COVID or whatever the reasons are. They don't care. Or you're going to be paying a significant amount of money for a professional mediator. Unfortunately, there's not anything in between anymore. The mediation provision, unfortunately, I don't know of its value per se anymore, just because Most of your EMD disputes are going to be between $1,000 and $5,000, which means it doesn't make any sense to hire a professional mediator because you're paying them $1,500, $1,600. So you're going to go down to the mediation, and you get 2 hours. And if you've ever done a mediation for anything else, 2 hours is not a whole lot of time. So I don't know how beneficial that's going to be, but that's the process. And then if you don't settle, then depending on the amount, you can file your action at small claims, or you can file at the district or justice court. But unfortunately, and I don't, it's not necessarily a negative thing against the county and the court for offering this system. I mean, they offer this for all kinds of cases. They've got a lot of dedicated people. There's nothing wrong with this process, but if you had experienced the LVR mediation process in the past, that is not what you're getting when you go to the Neighborhood Justice Center.
So the big thing that's important for us as agents is that right now with earnest money, I hear a lot of agents say things like, oh, you'll get this back. Oh yeah, in the contract you're guaranteed to get it. You can never say the words guarantee, right? Because we don't sell those. We sell houses. And so make sure that your client understands that this is leveraged risk. This earnest money is put up in lieu of the seller taking the home off of the market and going down the road of closing on the property. And so while the money leaves their account, as soon as it leaves their bank account, just like when you give money to your kids, you have no control over what happens with it, right? Because you don't control the title company and you don't control the court system. And so it's important that you at least don't scare your client in the transaction, but at least understand that this process is not as easy as it used to be. And even when they're right, even when you're 100% right, you still have to flow through this.
Is there any way, it seems like that's a real common suit that realtors face where they sue for earnest money, is that correct? They want the
Well,
earnest money
let's
back?
be clear. The realtors are not going to be involved as a party in any of this. It's going to be a buyer and seller dispute.
Right.
It's common.
It's kind of common, okay, because the reason I'm asking is, as their realtor, is there any way I could like word my RPA in a way that, hey, if anything happens, the earnest money comes back?
No.
There's no way.
So the RPA already does that. The problem is it is the title companies, and I don't mean to be negative, but I'm explaining what their scenario is. So the RPA says over and over again, if this happens, earnest money goes to this party. It says it in multiple different provisions for multiple scenarios. What the title company does, though, is they're not following that because it all comes down to their liability and risk. Buyer says to title company, release the earnest money to me or I will sue. Seller says, release the earnest money to me, title company, or I will sue. So the title company says, we are going to hold it until either you guys agree in writing or a judge tells us to send it. It has nothing to do with language in the RPA. It has everything to do with a title company attempting to mitigate their risk from being sued by both sides in those issues. So I spent many years, the Forms Committee spent many years trying to find out. This really comes down to not what's in the best interest of the buyer, not what's in the best interest of the seller, but how the title company is attempting to mitigate risk so they don't get sued.
So the other thing that's really important on this is it's another testament of why you as the agent provide options, not decisions, right? So if you, through the course of your actions, pick the title company and something happens with the earnest money in their opening instructions, remember when you open a file with escrow, they send you that nice notice, oh, thank you for the file. We'll send out the wire instructions to your client, and here's our escrow provisions. In those escrow provisions in some title companies, it says, regardless of the contract, regardless of what happens, the earnest money will go back to the party who provided it. There are 2 companies in town that have that in their provisions. Now, if I don't read the provisions, because a lot of agents don't, and the client then signs them upon opening, they've now agreed to those provisions, and I'm going under the assumption that they're going to get this money back down the road in court. Again, I'm not an attorney, so I'm not going to give them legal advice, and I'm not going to write verbiage that goes outside of the contract. But the point is, when they selected the title company, they took on the liability of everything that title company does, not me. And what do they usually say? Well, Chris, I don't know. I'm not a proficient in title companies. Who would you suggest? Well, here's the 3. The one at the top is who I use for my personal deal, right? I mean, who are they going to end up using at that point? Probably the one at the top that I use for my personal deal. But the point is, they made all of those decisions, not me. And I was shocked when, I'm not going to say the title company, but when it happened in the deal, I was the broker at the time, and we read the provisions, and the first line of the provision says, if there's a dispute, it goes back to the party who provided it, you can settle it in court later.
Yeah. So the short answer is,
You're an attorney, you don't give short answers.
I thought that was a short joke. So the hard part becomes is, yes, you can go down and fight. If you've got a mediation provision, then you're going to have to mediate, and then you're going to have to go to whatever court. And is there a chance you can win? Yes. Can I guarantee that you're going to win going before small claims in a court? Absolutely not. No lawyer can. The problem becomes is the opportunity cost that you're looking. If you're fighting over a $3,000 earnest money deposit, to kind of put it in perspective, for this mediation that I'm going to in about 2 weeks, I've got to drive down to the Regional Justice Center downtown. We're going to be there for a minimum of 2 hours. I've got to prep for at least an hour, and then we've got travel time back and forth. So my client's going to probably end up paying me between $1,200 and $1,500 just to show up no matter what happens. Then there's the opportunity cost for the client because they have to be there the entire time. And so oftentimes, my best advice to people, particularly when you're fighting over $3,000 or $5,000, the numbers just don't pencil out.
Yeah.
You know, if you can get $2,500, if you could split it down the middle and move on with your life, that may be the best long-term cost of taking the emotion out of the situation. You know, if you're fighting over a $25,000 or $30,000 or $50,000 issue, that's a different discussion. That's a different scenario. But the clients that I feel the worst for are buyers and sellers fighting over $1,500, $1,000, because to be honest, you'll blow more than that hiring me just to show up than you'll ever get back. So it's a difficult scenario when you're dealing with the lower earnest money numbers.
So let's go down another road, because if I do have a dispute, one of my standards of practices has been that when I know a contract is going in that direction and I know that we're going to end up at that place, a lot of times we'll end up with some type of settlement where they'll send over and say, well, we'll split it, or 60-40 or whatever. I've come to find out that, you know, a few $100s invested in a letter from an attorney, have you met my attorney? A few $100s invested by my client to have him write a letter. For some reason, when he puts it on his letterhead, it becomes official, right? And that letter goes over pointing out all of the facts in the contract that no one's going to look at later, as you pointed out, but at least it's our position. And I don't like having any dispute. I just have never been like this where I don't understand the position I'm defending. And so if my client so chooses, I've directed them to Dave and other attorneys just to write a simple letter. How much would you charge to write a letter?
It depends.
We're going to hear it here first.
Well, I can't give you a specific scenario because it's all going to depend on what the issue is.
Like 1 page, you know, with letterhead.
That would be
Depends on the research.
I know it's going to cost depending on what you have to do with the case.
That would be a few $100s.
Okay, he said a few $100s. Great. Is there a coupon code for that, or?
So and I wanted to say it depends, because what you're hiring an attorney for is for them to look at the scenario and say, this is what I think your chances of success are, this is what your chances of success are not. I find it very fascinating. I see all kinds of realtors who are writing emails saying, you know, we're going to win this if we go to court, or we're going to win because of this. And I've been practicing law for 20 years, and I have never told a client I can guarantee success. There's a lot of different analysis. I mean, you get analysis from different attorneys who say this is the right answer, this is the wrong answer. Well, that's all fine and good, but we don't know what the judge is going to decide. And if you're going to small claims court judges are not full-time judges. They're lawyers who are 1 or 2 days a week, go down and hear those cases. They could be a criminal defense attorney. They could be a slip and fall guy. They could know very, very little about real estate. And that's who you're putting your trust in. And it's not like in the district or justice court where, you know, those judges are elected, they're appointed by the Constitution, there's a vetting. These people are literally lawyers 2 or 3 days a week and go down and hear hearings for an hourly wage. And so that's who you're putting your trust in. So the best answer right now, particularly with COVID and the mediation requirement, is if you can reach a resolution, I would recommend that you do. Particularly if you're talking about a $3,000 or a $1,500 earnest money number, because the numbers just don't pencil out. I mean, you got to pay $300-400 just to file down a small claims court.
So let's talk about one of the things that you brought up in an email that you sent out to your clients was about real estate agents being careful of practicing law without a license, where they're writing long addendums that have many different terminologies, where they're putting in an email, we're going to win this, or here's the whole thing. Talk a little bit about that and what we shouldn't be doing as agents.
So there's a lot of concerns with that. Unfortunately, the Nevada Supreme Court, when they've defined the definition of practice of law, they intentionally have said that this is a gray area. So they're not going to say, and you guys, you realtors, God bless you, you want to say, okay, Dave, if I do 1 and 2, am I okay? But if I do 3, I'm not. And the Nevada Supreme Court has come out and said, that's not the analysis. The definition of practicing law in the state of Nevada without a license is advising any individual on any issue that impacts any legal right. So apparently everybody practices law without a license. Just think about that. Advising any individual on any issue that impacts any legal right. That's the definition. And they've specifically said, we're going to look at the facts. We're going to want to know what was the case, what were the issues that brought you to make that decision. So it is not going to be one of those things that's going to be easily taken care of. The problem that you also have with drafting exotic addendums or exotic additional terms is that's where you can get into all kinds of trouble. Because that case that the Nevada Supreme Court ruled the definition of the practice of law, there's about a sentence three paragraphs later that says, individuals who are filling in already pre-prepared, reviewed by attorney documents are not practicing law. So the fact that you have realtor forms from your local association that are vetted by counsel, that's the exclusion that the Nevada Supreme Court has identified. So if you ever get in that situation, when I was in-house for the realtors, the answer was always going to be, we are running straight to that exemption. They do not practice law. They do not write additional terms. They're not practicing legalese. They're not drafting new information. They're taking forms that are already drafted. They're filling in the pertinent forms, the blanks, and they're submitting those. And anything beyond that, they're telling their clients they need to go speak to an attorney. So that's where I would be very careful. And the other thing is that there's case law throughout the United States that says that errors in drafting are interpreted against the drafter. So when you write your super fancy document and there's a mistake there, you're the one who's responsible. And if you don't think that your favorite buyer or seller will turn around and sue you when they find out that the language you wrote is what caused the problem, that happens all of the time. So I would tell you, be very, very careful when you're adding additional terms. Be very, very careful when you're trying to craft. I'm not talking about saying washer and dryer to be included, those kinds of things. I'm talking about when you're getting really, really exotic and you're writing stuff that you deep down inside, you should at least go talk to your broker about. The appraisal contingency, X dollars above it, that one is one that creates all kinds of problems. I know that the state association's legal hotline has come out and said that that's not accurate. I know that there's a local brokerage who's got an attorney in-house who says that no, the language that you say X dollars over appraisal is controlling. There's no case law on this. So you've basically got a bunch of lawyers who are standing up saying, I'm right, no, you're right. And then one of you is going to be the unfortunate realtor who's going to be the one who goes down there and finds out if you're right or you're wrong.
Hopefully not me. Okay, so we're going to change gears. Anyone have any questions on what we just talked about before we leave this topic? So many questions. Okay, great. All right, so another one that's come up a couple of times, and this comes back to the changes that NAR has done with our code of ethics. There was a post on Facebook the other day that someone was being very vocal about their opinions on government and about the way medications work and everything else. And we have all of these people out there that are becoming experts without any licensure, right? And so what is the liability a real estate agent could have, not just with the code of ethics, but with their clients for the things that they post on Facebook and social media outlets?
Okay, so if I had my druthers, I would tell you to not have a social media presence. That's the easiest way to solve
that ain't gonna
this. So let's talk
too many games.
We all love Candy Crush. So let's talk about what NAR has done to address that, and then we can talk about the other issues. So NAR has come out and made the position that Article 10, generally speaking, the Code of Ethics used to only apply to real estate transactions. So if Chris said, Dave Sanders is a jerk because he's a Dodgers fan, That's not a violation of the Realtor Code of Ethics.
Even if it's true.
It's an outright lie, but it's not a violation of the Realtor Code of Ethics. And what happened was down in, I believe, Georgia, there was a realtor who was posting anti-Semitic, very, very racist comments from his realtor social media page. And the local associations went to NAR and said, this is not acceptable. And NAR agreed. So Article 10 now applies to everything you do on social media. So if you post a statement that is hate speech, that is a violation of Article 10, that talks about a protected class in a derogatory fashion, that is a violation of the Realtor Code of Ethics, whether or not it has anything to do with real estate or not. So NAR has taken the position that we do get to police your social media comments. Now, what I don't know, what it hasn't been clear, is whether or not liking someone's comment that says that is enough. But my point is, you have to be aware of the fact that social media comments, regardless of whether or not they have to do with real estate, if they impact one of the protected classes under Article 10 or fair housing, is a violation of the Realtor Code of Ethics, period. It doesn't matter if it has anything to do with real estate. It doesn't matter if it's your personal opinion. It doesn't matter if it's your personal page. If it's out there and you're identified as a realtor, NAR is taking the position that they can and will enforce against that. So don't do that. That would be the first thing. The second thing is you've got the standard requirements under NRS 645. The division takes the position that every single social media post is akin to a mailing. So if you're going to do a bunch of mailings to a group of people out in your neighborhood, you know that, okay, I've got to have my name, I've got to have my license, I've got to have my brokerage name in a prominent spot, all of that. They take the position that every social media post is like that. Now, if you're like some realtors, I know that you have a personal page and you've got a professional page. Well, as soon as somebody from high school says, hey, Chris, can't wait to move to Vegas, want to buy a house, your personal page has now become a professional page and now must comply with all of the requirements under NRS 645. And then here's the fun part. Slander, defamation, all of that fun stuff still applies on social media. One of my favorite stories about social media was, I don't know if you guys remember, there was the Boy Scout troop in Utah that videotaped themselves pushing over millions of year old sandstone rock formations. They claimed that they did it because it was a safety violation. Well, the federal government arrested them for felonies because it was, they intentionally destroyed federal property. But what most people don't know is the guy who actually pushed the rocks over was suing his employer, claiming that he had a permanent back injury, that now they're no longer to work anymore. Well, guess what? His employer's attorneys got the video that he posted on Facebook, and it ended his lawsuit. So what I would tell you with social media is, don't post anything that you wouldn't want your mother, your clergy, or a jury of your peers to see.
Well, that's where I got the post I shared that got me in trouble, right? So the point you said that is important is that we are business owners that have made the decision to be in business and real estate. And I have a lot of personal opinions and beliefs, but you're going to notice if you go on my Facebook page, I don't post a lot of that stuff. I mean, it'll be food, some bars where you eat the food, and once in a while I'll post a picture about the kids and the family I care about. But I do not go on and get political, not because I don't have opinions, because I can't afford to lose a client because of my opinions. Every client matters, and I don't care what your political beliefs are, I don't care what your religious beliefs are, I'm here to sell houses. And the whole thing is that is what we see happening in the marketplace right now, is my Facebook feed is full of realtors saying things they shouldn't. And we've all seen it, right? And the MLS is full of realtors posting things in photos and things that they shouldn't, right? But the whole point is to be better at business so that you're not in this problem. There are people out there right now that we've seen on a board level that are just waiting for you to post something so they can throw you under the bus.
And more importantly, you're going to have clients. I mean, I'm not saying that you don't have to post things that mean a lot to you on social media, but there are consequences to that. It is not unlawful for me to say, I will not work with Realtor B because they are a Giants fan. And I am still really, really upset about the game last night. So I'm going to go find a Dodgers real estate agent and take my business to them. That is not unlawful for me. If you want to post these things on social media, there's nothing wrong with that. But you have to realize that you may or may not be attracting the type of clients that you want to work with. because they can look you up on social media. And if your social media post is full of confrontational comments, which you have every right to say, they have every right to say, maybe I should work with somebody else.
So this question came up, which I thought was kind of interesting, thought process-wise. If I do a deal today that closes, let's hope for 7 days, closes in 7 days because it's all cash, how long am I liable for the things that happen under that transaction?
Forever and ever.
It's not just a few years?
So generally speaking, for the Realtor Code of Ethics, it's of 180 days from the violation of the Realtor Code or when it was discovered. So when the phrase "when it was discovered" can open that up significantly. Civil liability, the statute of limitations is generally speaking up to about 7 years. Again, all hinging on when it was discovered. So there is a significant amount of time that you can be held responsible for. And it's not just the statute of limitations. The statute of limitations is the time frame that I have to bring a lawsuit against you. That is not the time frame that the lawsuit will be adjudicated. Does that make sense?
That's a big word. Explain that.
I get paid by the syllable, so I just made it up for a vote right there. So what it means is that I will bring a lawsuit. I have like 7 years to bring a lawsuit, okay? But I have an additional 5 years beyond that to get it to a jury trial. So yes, I may have a 7-year period where I have to keep my documents. But if I bring a lawsuit, litigation can take 2 or 3 years. So we could be discussing cases, events that occurred 7, 8, 9, 10 years ago. And depending on how you answer those questions, the jury is going to be looking at whether or not you're credible, which is why we want you to not rely on telephone calls, which is why we want you to have emails, because they have date stamps, they have time frames, they have an email address. It makes it very easy for me. When we go to trial, I have to do what's called, I have to lay an evidentiary foundation for all of you Law and Order fans out there. So I have to be able to prove that this document is valid. Text messages are difficult because typically you're going to send me a screenshot of your text messages. It's difficult for me to prove dates on those because you're screenshotting. It's difficult for me to prove who actually got this, because why you decided to name the other size realtor Big Angry Monster number 17, I don't know. But it makes it very hard for me to identify who that person is. Emails are a lot easier in that sense. Letters are better in that sense. And we can refresh your memory with those documents. But if it was a phone call, it's going to be a he said, she said. And basically what you're gambling on is that a jury of your peers in Las Vegas is going to like me as a real estate professional or a property manager more than the poor victim, who's going to throw their hands up and say, I relied upon my realtor. They never told me this. I did everything they said I was supposed to do. And then your answer is, but I told them. Yes, I've been doing this for 25 years. No, I didn't write it down.
So the reason I bring this up is we're getting towards the end of the year, and one of the things that I've done as a standard of practice is I go through and clean out my email for the year, all of the things I've let pile up. And I've even noticed that, I've had a few emails that need to go back into the file that just never made it. And one of the cool things with SkySlope, I can take all of them together, I can put them together in one thing and send them to my file. And so what I see a lot of agents do is they do what they have to get paid and get those documents in there, but they forget about the communication logs and the text chains. And I know that you've been that person sitting there at the end of the deal a couple of days later and you're going through your phone and you see that text chain that's gone on for forever that kept you up at night when they would hit you in the middle of the night for properties, and you've taken it and just deleted it when it should have been something that may have gone to your file. To Dave's point, make sure you name it right and it's dated. But just all of those logs that you have. And the reason I thought of this is I went into a Yahoo email. Remember Yahoo? Yahoo!
I'm not that old.
Yeah. I still have my Yahoo email, and it was the login for me to get into a different account that I have had for forever, and so I had to go back into that email. And I realized, back 15 years ago when I started, I used to have file folders in that email, where I would keep information until it would go in there, and I still have those file folders. And so make sure you're putting all of that into our file, because if it's not in our broker file, it doesn't exist.
Not to frighten you.
Don't frighten us. It's almost Halloween.
But there's two things. One, for example, say that you have a bunch of emails that you didn't send into SkySlope to your broker. And the division says, broker, send us your entire file. Broker sends a file. You as agent say, oh wait, here are these 25 other emails that vindicate me, I'm going to send those over. I have seen the division file an obstruction of justice claim against the agent saying you are intentionally interfering with our investigation because you didn't provide the entire file to your broker like you were supposed to under state law. And considering that the division can now fine you up to what, $15,000 per occurrence? And charge you for the cost of investigation, your failure to send those emails could be a very costly one. Second, if you ever have to get to litigation and you say stuff like, I had emails but they're not here, the other side can argue to the judge and say, Judge, we want you to order the jury to infer that the realtor intentionally destroyed these emails because they were bad for him or her, and take a negative inference on that decision. So it is far better for you to over-include documents than not, because there are significant consequences.
Okay, let's go down a different road. We've got about 15 minutes left. So believe it or not, when I was a kid, we lived in Desert Shores, and one night in the middle of the night, some family opened our front door, came in, and the grandmother, was on a walker and fell off our front step and was screaming in the middle of our living room. And of course, my stepdad came running out, we came running out, and they're like, who the hell are you and what are you doing in our house? You know, and they had used their front door key that matched our front door key and opened our door. That's a different conversation. But it leads me back to the idea, if someone slips and falls, if I'm showing a property with my buyer, and my buyer slips in the property, or I as an agent have something that happens to me in a home, who's liable and how does that get settled? Because we just had that kind of issue happen just recently with a dog bite in a property.
Okay, so the listing agreement has specific language that says that the seller acknowledges the, we added this language about 8 or 9 years ago, that the seller acknowledges that there are potential liabilities related to showing the home, and that they agree to indemnify the listing agent as well as any other agents. If you want another reason for using the buyer brokerage agreement, the buyer brokerage agreement has additional language like that, where the buyer says, I understand that there's some potential issues with showing property, going to visit property, and I take those issues on themselves. That's a general indemnification. Now, hypothetically, if a seller knew that the steps into the home were loose and told you about it, you didn't do anything, and somebody slipped and fall, that's a completely different analysis. I mean, you have to be, you have to mitigate damages. You can't, let a known condition just kind of sit and fester. But there is language to the extent that we can put it into the listing agreement, the buyer brokerage agreement to protect you. The seller, again, is going to be the homeowner. They're going to be the one who's going to primarily bear the burden, because someone coming to view the home is technically considered an invitee under the rules of tort law. But then there's going to be, there's the indemnification language, yes, there's that. So the ideal situation is to not get into that situation at all, making sure that when you're having your conversation with your seller, hey, people are going to be coming through your house. Are there any conditions that we need to know about that may impact, someone coming in and through the property? Sure.
I just want to share a story because it's kind of funny. It was like almost the Murphy Law, one thing can go wrong, so everything went wrong. So I was showing a condo or a townhouse in Henderson, and I opened, and it's had a little front, cement slab in front of the front door. And I opened the door, and a dog jumps out. So it was 2 adults and their adult son. The adult son took off with the dog. We proceeded to go in the house. Oh, wait, stop. I turned and twisted my ankle off that slab. Okay, but it's okay, I'm okay. I'm going through the house. So the guy comes with the dog, we go inside. There's a long-haired, chinchilla, no, it was a rabbit, a long-haired rabbit thing. He really liked my client's pants.
The story just keeps unveloping, right?
He sprayed on my client's pants. Oh, no.
So just for those at home, Sherry was showing a property, opened the door with her client's dog, jumps over the client's, runs off. Kid goes after the dog, people go into the house. There's some type of furry rabbit animal that's in there that takes a liking to the buyer and does something all over their pants. And
so she sprained her ankle.
And she sprained her ankle.
It was just catastrophic. And the place was
Did you guys buy the house?
No.
But
Oh.
they actually bought better in Summerlin.
Okay.
So in that scenario, you as a seller's agent, your discussion needs to be, if you've got animals, they
Yeah,
need to be
take care.
secured. Just
Yeah.
like any liability as a pet owner, that doesn't change just because you've listed your property.
Yeah.
So that would be the first thing that I would say with pets is secure them, or if they are like I just got a golden retriever puppy.
I thought you were going to say
If
goldfish.
I'm not that cool. And she, bless her heart, is a little bit wild and crazy because she's like 10 months old. But if I was listing my house for sale right now, I would be packing up Daphne and getting her out of the house just because I don't want to have the liability. Now, do you have to, like, as an agent, buy a crate and pack those pets up? Absolutely not. All you have to do is tell them, hey, you've got these animals in here, it would be a really good idea for you to secure them or have them out of the property. And you do that
In right.
in writing, not by text. Don't get me wrong, I have an 18-year-old daughter, she texts me from the next room over and asks me for stuff. I get it. But text is not where you want to have these conversations. Because in 7 to 12 years, it's going to be the question, did you really tell the client this? For example, I had a multi-million-dollar mold case where we went to a 2-day mediation. And one of the issues came down to the agent who had been practicing for 30 plus years, who had sent them all kinds of emails about everything else, but magically did not have an email saying, go and get a mold test. And of course they found mold. So the plaintiffs, they sued everybody. The inspector, the listing agent, the listing brokerage, the buyer's agent, there were 7 parties. And we ended up settling for a very high 6-figure number because this agent did not send an email saying, you should probably go get a mold test if you're concerned. I'm not an inspector, but the only way we can tell whether or not there's mold in the house is for you to go to get a test. If we had that email, it would have been a very different case, but we didn't. She said, I told them over the phone. And then that turns into a he said, she said. Yes, sir.
I'm obviously not a licensed agent, but wouldn't that fall on the inspector? How would that fall on the real estate agent?
Standard practice.
Oh my gosh, you've never been sued, have you?
So far.
So basically, what the whole reason why the plaintiff brought a lawsuit against everyone is that they were trying to parcel out liability. Yes, the inspector was liable, and yes, the inspector paid. But the other argument of liability was we relied upon our real estate professional who is familiar with these process.
For 30
We
years.
don't know if we need a mold test. I'm just an innocent person from Las Vegas trying to buy a home. That's why I hired a realtor with your knowledge and experience, just because you're supposed to advise me through this process. And you didn't. And that was the issue.
Well, I just had a case like this right now, where there were water spots and the inspector suggested to do a mold test. And if they don't want to do a mold test, if they sign the mold and pest waiver, is that good enough?
So just real quick before you answer
We
that.
did the mold test, we did it, but
So,
I
but the-
still had him sign also.
But the disclosure just says what mold is. It didn't talk about the property, right? And his whole point in this case was that the agent should have stopped at that point and said, Mr. Buyer, I recommend that you do whatever due diligence you need before you buy this house, which may include another inspector, it may include a contractor, it may include a mold test. And I put that in writing for my broker file to show that I did everything I could to try to convince them. Turns out my client's a contractor and he knows everything about houses. So he's decided to go ahead and buy it. I get that story. Every client that anyone has in this company is a contractor, right? Because I hear that all the time. Oh, my client knows everything. He's built hundreds of houses. And that's the first person that's going to sue because they've built hundreds of houses and they know that when you sue somebody, you sue everybody in the deal, right? So, but his point is the one that we've been talking about the whole day is what documented proof in writing do you have to defend that that happened other than we said that while we were walking through the house. That's the whole problem that we see as an industry. Even if it happened and you said it when you're at the house, I would go back to my office and write an email to myself that said I was at the house with my buyers, it was 10 o'clock, the sun was coming down over the mountains, I know that, the inspector was this person, here's where we're at, and I told them at that time to get this done. And they didn't. At least 10 years from now, I'd have that email, and who makes up emails like that? Nobody.
I love that email. I do it all the time. This will confirm our telephonic conversation of today's date, wherein you told me, and I advised you that you should get a mold inspection, and you refused. If your recollection differs from the above, kindly contact me immediately. That is a very good CYA. Now, you don't have to use all that legalese. You can come up with your own thing. But basically, it is, hey, we talked about this today. This is what I remember our conversation being. If you don't remember it the way I do, you need to email me. Because that makes my life so much easier 7 years down the road, because then I get to ask the buyer, well, you said that this didn't happen. You got this email. Why didn't you answer? Why didn't you say, no, that's not what happened? I don't remember this. That's a much different conversation than you two arguing that the call didn't occur.
What if the person says, I never received your email?
But you got all the other ones.
Isn't this your email address?
Okay.
So then I get to go to the jury and say, so we sent a grand total of 179 emails to the buyer.
This is the one you,
This is the magic one that she claims she never got.
It went into my
I
spam.
got 17 more emails 3 days afterward from this email address. So who is telling the truth today and who is not? The real estate agent who is a professional confirmed the telephonic the conversations in writing, as is their pattern and practice, or the seller who brought this lawsuit is attempting to make a outright brazen claim for money they're not entitled to. You make that decision.
So, a lot of information. This isn't the Halloween special to scare the hell out of you or anything like that.
We do that at Thanksgiving.
Yeah, we do that. But the whole point is, you could be a great real estate agent. We have so many great real estate agents here that are doing a great job, and they're selling a lot of business, and they're doing everything right. It's just that one technicality of something you forgot to do that usually gets you into trouble that the attorney spends into an entire career, right? And so all it takes is that follow-up step, and that's the hardest part. Go back to your office, think of the follow-up, put things back in writing, and just document them so you have them for your protection. The nice thing about our signature app is it does date and timestamp things that are on there, and we're able to go and get those, and you can send documents in it, you can circle it, you can highlight it. All of that could go directly into your file. It's just another step. But again, it's the defense, right? I would hate to be sitting with him, and the one thing that's going to keep me from winning this case is that I didn't send one email, right? It would be horrible. We've got about 3 minutes, so Todd has a question for Dave.
No.
And I got to repeat this question for the audience. Yeah, that would be great. Well, here, you've got a cast on. I'll walk to you.
So Dave, we're seeing a lot right now where a buyer comes into a property, writes an offer on the property, and the seller says,
There you go.
sorry, can you see me? The seller says, great, love your offer, we'll take it, but we need a rent back. So we're gonna need to rent back for whatever it is, a week, 10 days, 7 days, 3 months, 60 days, whatever the rent back is. And the buyer says, yeah, great, no problem, we'll give you the rent back. And in the negotiation of accepting the contract, they never come to terms on what that rent back looks like. How much is it gonna cost? Is there a security deposit? Who holds the security deposit? All of those things. And we get past due diligence, we're getting down to it's about time to close, and the seller said, or the buyer says, hey, here's a post-possession addendum, and it says that you're gonna pay me $30 a day, and you're gonna put $1,000 security deposit down, and the seller goes, no, I'm not gonna do that. I'm not gonna do any of that. And so now we're the day before closing, they haven't agreed on rent back terms, and the buyer now says, well, I can't buy it if they're not gonna give me the terms, or the seller says, well, I'm not gonna sell it if you don't give me the terms. Talk us through that.
I never thought that when I started doing real estate that the phrase rent back would be the thing that keeps me up at night. I don't like them. I don't like them at all. I don't like the post, and I'll be honest, I wrote them. Shame on me. I don't like the pre-possession.
It wasn't your fault. We made you do it.
I don't like the post-possession addendum at all, because of Todd's scenario right there. Because there's so many things that can go wrong. For example, the state of Arizona, when I was doing my research, they actually came out and said there's so many problems with these documents that as the Arizona Association of Realtors, we're not going to do it. If you want to do it, have your client hire an attorney to figure it out. Because here's the problem. Post-possession addendum, you are now complying with NRS 118A, the landlord-tenant statute. There are very, very specific requirements that you have to comply. Probably haven't talked about to the buyer that, oh, by the way, the seller is now going to be a tenant. So if the AC goes out 2 days after close of escrow, guess who's fixing that? You are, because you are now a landlord.
We've had that happen too.
You have the.
The seller will fix days?
No, the landlord who is now the buyer. The buyer is now a landlord. You have a lease agreement.
Yeah.
So the buyer, forever long that period is technically considered a landlord pursuant to state statute. So for me, the only way I would do this, and I know no one likes this, but this is the lawyer answer, I would have them sign a lease agreement. Because a lease agreement is actually designed to address all of these things. It talks about what happens with,
Even 1 month, 2 months, right?
if it's more than 48 hours, I would tell you to sign a lease. That's just me. I know that, speak to your brokers on this. I'm giving the lawyer answer because I have seen these things go off the rails. We talked about this in the past. There is a property in Southern California. Somebody spent about $7 million in Laguna Hills.
Still haven't moved in.
The seller hasn't vacated. They can't evict them. That's your worst case scenario. Seller doesn't get out.
But on his question, and the weird part about this is the parties don't have defining terms, but they have a defining action. They must do this document, but they don't have terms for it.
So technically, what you've got is you've got a contractual provision that both parties are supposed to comply with, and both parties are in breach.
Well, so I understand that means if they're in breach, that we have to go to court, that can take years, that's why there's a $7 million house that's sitting with somebody in it.
You're actually
My-
asking me for ways to actually be proactive.
Well, my question would be, as agents, when should we, whether we represent the seller and the buyer, when should we be negotiating these terms?
If I was the buyer's agent, and the best way to be absolutely certain that we can get out of this, if the seller's giving us a hard time, I would make sure that I have communicated all those terms and put the documents over during your due diligence period. So that you have that due diligence thing to say, look, we're doing a due diligence, you want to do a rent back, here are the terms we're giving you, you're refusing to execute them, so we're not going to buy the house, we're in the due diligence provision. That would be the best scenario. The worst scenario is to wait until the very end because all I'm thinking to myself is if I'm the seller or the buyer, I'm suing the agents who let this go until the very end. You're the professional.
Yeah, so that's my point, is so many agents leave it to the end,
Yeah.
because, oh, we'll figure this out, and no, because you get down to the
And
end, and nobody wants to play
I'm
ball.
waiting for Tom to laugh. I'm a lawyer. My job is to take advantage or take advantage of the other side whenever I can in a legal and morally ethical way to do it. But in this
That's an oxymoron.
But in this situation, this is the thing that I don't understand. If I am representing the buyer and the seller wants a lease back, it is in my buyer's interest to be the party that sets those terms first. Because we're not being the unreasonable one, it's the seller. If I'm the seller's agent and they need a rent back and they're worried about whether or not their new home build is going to be built, I would want to be the one who starts that.
So when he
To
wrote
control the narrative.
When he wrote this document, we had a series of videos that came out that probably are long gone. But the point was that all of the blanks in the occupancy agreement should have been answered during the purchase offer or during the seller's counter, right? And so there's 4 blanks in there: the term, the rent amount, the time frame for the contingency, and the deposit. And so if you're writing an offer and you're allowing the seller to rent back, all 4 of those should be answered in the offer, that then they can just be put into the agreement because it's already contractual, that you're going to do it before the due diligence and here are our terms. That's how to write it the right way. And if you're the listing agent and you don't like those terms or the seller wants more, then you should have countered those specific items in that document that way, or to your point, countered and said, I want a lease instead. But the lease has hundreds of blanks. And so you would have to answer those blanks, or at least the big ones that would be a bone of contention, because are you going to negotiate with me over the garage remotes? Probably not, but you're sure going to negotiate over the timeline and the rent amount.
Well, let me flip this over. What if I am the listing agent and the buyer comes in and says, yes, we'll give you a rent back, and then during the due diligence period, we're not able to come to an agreement on those terms, but as a seller, I have no right to cancel the contract because there's no contingency there for me to do that. So I'm kind of stuck as a listing agent or as a seller if I can't agree to the buyer's
But you passed the
terms.
time frame. That's the other point. If I said that you had to have that as the buyer's agent at that point, before the end of that
Oh,
time frame,
they've
you've passed it.
supplied the terms. They've supplied the terms the buyer wants. The seller just won't agree to them. But my seller has no way to now go, because I don't agree to your terms during due diligence, I want to walk away from the contract. It's not possible in our contract. So My point is that if you are on the listing side, go talk to your broker on how to write something that says that if we don't come to terms during the due diligence period, my seller now has a contingency or a right to cancel the contract.
But that's the point. We should not be coming to terms during due
No,
diligence.
I
We should already
agree.
have them mapped
Look,
out,
if the
right?
world was perfect, I agree.
Well, the world was perfect, we wouldn't have the question.
But it is never perfect, and
That's
you
the whole
need to
point.
protect your sellers, because now they're stuck having to agree and they can't cancel a contract.
Yeah.
It could be something as simple as, should the parties fail to reach an agreement on the leaseback terms, the seller reserves the right to cancel the contract without any penalty.
Exactly.
That would work.
But it's not
The only
there.
other thing that I would tell you.
There's a fifth one, by the way, I forgot. You should transfer everything through escrow. Because that's the other thing we've run into a problem with, is they transfer it after escrow and the check bounces, and none of that's good.
With the caveat that I don't know if I would want the deposit being held by the escrow company. That would be just.
Sure. We're not even gonna go there, we don't have time. Let's give it up for Dave Sanders and his legal advice. And so now you're gonna watch me win some alcohol. I'm glad you're all here for this. And so Sherry's gonna draw, and how are we doing this so it's all fair?
First of all, does this work? Yeah. They talked soft or the microphone wasn't strong? You guys, $900 we have made for the whole, whatever, I think it's 4 weeks, right? $900. If I had 5 more people that want to donate 20 each, it would be $1,000. Just saying. Just saying, 5 people, 20, $20 each for booze. For booze, just booze.
There's one right there, $20.
Oh, Gail, you're Gail. 4 more. I feel like I'm auctioning
Jason,
off
he's got 20
something.
in there.
4 more. Go,
There's
see
20.
Roya. Okay, we got, 3 more, 3 more.
All
Right
right,
back
all
there,
right,
back
all
there,
right.
Roya.
$20.
Oh, Chris.
I'll keep the tickets I got.
2
though.
more. We'll have
Too much.
$1,000, you guys. This is so exciting. Here, give it to Royal. She'll give you your tickets. And 20 goes to Chris. I guess I better help her,
We
huh?
will have raised $1,000 from this. Yeah. Now that we've got those people in, and those of you at home, you're missing out.
Yes. No more boobs and bacon.
We only need one more.
They could with Venmo.
Yeah, okay.
Yeah.
One more 20.
So tell me a rebate will.
Do you think it's safe to say Venmo?
Okay, we got it, Todd's doing it.
Oh, we got it. We got $1,000.
Beta's doing it too. Come on, Beta.
Yeah, tell me a rebate is.
All right, did we do it? Did we give all the tickets out yet? Oh, Kim's over there helping. Thank you, Kim.
Like, we're gonna need a
1,020. Oh, you guys, that's so fabulous.
Got shook up.
So don't forget, I forgot to even mention the walk, you guys.
Are these my tickets?
Yeah, you're putting your tickets in.
Was this my set of tickets?
Yeah.
Drop that ticket. Ah,
What'd you do? You put them in there?
I might win twice.
Oh, you got to drop this ticket on there, right? Don't say drop this ticket.
Okay.
Yeah, it's a lender to screw it up.
Okay, never mind. We're good.
Okay, that's your second 20.
No,
Where's your first
I
20?
told him not to give it to me. I don't want more tickets in there, I might not win.
Oh, yeah, right, I get you. Okay, hold on.
They all say drop this ticket.
Just put it around your neck.
Just put it in there.
Don't know. Don't get confused.
Those are my actual tickets. These are? No, those. Somebody's gonna win something.
Okay, so let's talk about the walk. The walk, Making Strides Against Breast Cancer, is October the 24th, you guys.
I'm mixing it up.
That's 2 weeks.
October 24th.
It's a Sunday. Are you going to be here? I need to talk to your vacation planner.
Okay, they're all mixed up.
Okay, so we meet October 24th.
Oh, wait a minute.
I'm just mixing them.
You got more?
We are meeting at Lazy Dogs, downtown Summerlin, 7:30 in the morning.
Holy mackerel.
T-shirts will be provided, the Tata Alliance, and we walk about 3 miles. And it's so exhilarating. It's really a lot of fun. It's all rah American cancer. I'd say there's a few thousand people that are all dressed in pink out there. Chris, you're so
And
good.
the one guy that didn't know there was an event going on.
Hey, Chris, you pick them this time.
No,
you
that's
can't,
unfair.
because you paid. Forgot about that part. Pick me. It's just so crazy. Okay, first one gets to pick the prize. First and second, third gets the last. How's that, you guys? Okay, I really mixed them. Okay, here, this one fell out.
We're giving away a Cadillac, right?
There's more? Well, wait, there's more.
No.
You didn't get your tickets, did you?
If you send this share, well,
Oh, my.
I didn't know. Hold on, here we go.
my Zelle number, by the way.
We got 20 more tickets coming in, coming in. It's so hard at the end of that roll. So you all get a t-shirt, Lazy Dog, Saturday, October 24th. Tom Blanchard will not be there.
Right.
I think next time we should do one ticket for $20. It's so much easier.
Okay,
There we
Chris,
go. Now
maybe
give
you're
us some
right.
liquor.
I'll do it.
Maybe, because this is like really a lot of tickets.
Yeah. Way too many.
Falling out.
Hold on.
Okay, it's really-
We want to make sure Beta wins. He'll be right on top.
So you at home, did you see Makers, Mark, Valentine Scotch, and not just Cuervo Gold, this is blue agave. Pardon me?
It's very good.
Yeah, this is like good stuff.
Smooth,
Somebody brought me this as a gift.
especially after the third shot.
As you see, I don't drink it. Okay, yay.
We're serious this time.
Okay, here it goes. Are we all ready? You got your tickets ready?
Everybody is waiting, anticipating.
Can we go, Roya? She said yes. Okay, here's the first number. 254-7680.
Oh! Ah. Please hold.
Hold on. It's Kim again! Wow!
Yay, congratulations.
Chris is so happy for you. Come and pick, Kim.
Which one would you like, Kim?
Tequila!
Tequila! Congratulations, Kim. Nice job.
The front desk! Yay for Kim. Okay, next one is 254-7884.
That was someone in the later purchasing.
7884.
What is it?
7884.
I got it.
He always wins. He even won at the golf tournament.
Oh, really? That's
It's
great.
Beta.
Oh, it's Beta. Yay, Beta.
Which one do you want?
Especially because he
Definitely
worked so
Beta.
hard. Thank
Definitely.
you, Beta. I'm so glad you won. Okay.
All right, Valentine's is next.
Nice scotch. Nice. Give this to your classy client.
It's blended scotch.
It's a good one.
It's been aged in the bottle since 2018. It doesn't age in the bottle. That's a trick.
Yeah. Even wine. Okay.
I've never had one stay in the bottle.
Right. Good point. 254-7608.
No, wait a minute.
That's gotta be one of the early ones.
7608.
Is that you, Chris?
That's me. Chris.
Yay! Yay! You can do that to somebody.
Yay!
Thank you guys so much. $1,000. Isn't that great? Thanks, guys.
Thank you guys for being here. Have a great week.